Hello, welcome back to Learn Oikonomia. In this video, we are going to look at the allocation of property rights. For this, take the case of a small lake that one firm used for waste disposal and other used for water supply. Okay. On a deeper thought, we can lead to a more fundamental question: which one of the firms is really causing damage, and which firm is the one which is suffering from the damages caused by the other firm? This may sound counterintuitive, as the natural answer would be that the waste disposing firm is, of course, the one causing the damage. However, it can be argued that the presence of a food purchasing firm inflicts damages on the waste disposing firm because its presence makes it necessary for the latter to take some special efforts to control its emissions. The problem may come about simply because it is not clear who has the initial right to use the service of the lake. That is, who effectively owns the property rights of the lake. When a resource has no owner, what happens is that nobody has a strong incentive to see to it that it is not overexploited or degraded in quality. Private property rights are, of course, the dominant institutional arrangement in most of the developed economies of the West. In the case of developing economies, these economies are now moving in that direction. They access FMDRT with the operation of that institutional system when it comes to person-made assets. I mean the assets made by by people, such as missions, building, and consumer goods. Private property, land, is also FMDR arrangement. That means that if somebody owns a piece of land, he has an incentive to see to it that the land is managed properly so that it would maximize the value of land. If somebody comes along and threatens to dump something onto that land, the owner may call upon the law to prevent that kind of dumping, because it is his land. He is the owner of that land, and he wants to prevent others from misusing his land. By this diagnosis, the problem of misuse of many environmental assets come about because of imperfectly specified property rights in the case of these assets. Coming to the principle of what we are going to look into, consider again the case of a lake and also two farms. Apparently, there are two choices for vesting ownership of the lake. It could be owned either by a polluting firm or by the firm which is using the water for consumption. Okay. How does this choice would affect the pollution in the lake? I mean, the level of pollution in the lake. Would it not lead to zero emissions if owned by the one firm and controlled emissions if owned by the other? Not necessarily. If owners and non-owners are allowed to negotiate. This being the very essence of property rights system, the owner decides how the asset is to be used and how to stop the other person from making some negative use of the asset which the owner considers. So you have to understand this. You can understand this by making use of the figure given here. Suppose a marginal damage function refers to all the damages suffered by the brewery, that we can call this as firm A. Assume the marginal abatement cost curve is applied to the firm emitting effluent into the lake. We can call that firm as the firm B. Certain assumptions have to be made with respect to the ownership of the lake here. Theoretically, the same quantity of emissions would result in either case, provided that the two firms can come together. They can strike a bargain about how the lake is to be used. In the first case, suppose that the firm B owns the lake. In this case, firm B may then use the lake in any way it wishes. Suppose that the emissions are initially at EL. Okay. And firm B is initially devoting no resource at all to the emissions abatement. But is that where matters will remain? At this point, marginal damages are $R, where marginal abatement costs are nil. The straightforward thing for firm A to do, therefore, is to offer firm B some amount of money to reduce its affluent streams. For the first ton, any amount agreed between 0 and $R would make both the parties better off. In fact, they could continue to bargain over the marginal unit as long as the marginal abatement cost Firm B would be better off by reducing emissions for any payment exceed the marginal abatement cost. Firm B would be better off by reducing emissions for any payment in exceeds of its marginal abatement cost, whereas any payment less than the marginal abatement cost would be would make the firm A better off. In this way, bargaining between the owners of the lake, that means here we assume that it is firm B, and the people who damaged by pollution, people who are damaged by pollution, would, that means firm A, this will result in a reduction in the damages caused to the lake, or reduction in affluent is considered to be point E star, which is a point at which the marginal abatement cost equals the marginal damages caused by the firm. Suppose on the other hand, the ownership of the lake is vested in firm A. The firm A, that means the firm which is damaged by the pollution. In this case, we might assume that the owners would allow no infringement of their property, that is, the emission level would be 0 or it can be close to it. Question here is that this would be whether it would whether this thing would remain. If not, again owners and others negotiate, right? In this case, firm B would have to buy permission from firm A to place its waste in the lake. Any price for this lower than marginal abatement cost but higher than marginal damages would make both the parties better off. And so, by similar process of bargaining with, of course, this payments now going in the opposite direction, the emissions level going into the lake would be adjusted from low level where it started and toward the efficient level, that is E star. And at this point, any further adjustment would stop because marginal abatement cost, that is a maximum the polluters would pay for the right to emit 1 more ton of effluent are equal to the marginal damages. The minimum firm A would take in order to allow firm B to emit this added ton. So, we have seen in this example, if property rights over the environment asset are clearly defined, that means that bargaining among the owners and prospective users is allowed. The efficient level of effluent will result in irrespective of who has initially given the property right. This shows the famous Coase theorem, which is put forward by Ronald Coase, and we will be discussing the Coase theorem in our next video. So, I hope you understood the property right distribution aspect or allocation of property rights. Please like, share and subscribe to this channel, and thank you for watching. And also I welcome you to my Telegram group and Telegram channel to discuss your doubt. Thank you.